Hi there. So it's Christine Scudder here, and going to be talking about social work laws and public schools. Is it HIPAA or FERPA? You've always wanted to know, and all will be revealed today. So I want to talk a little bit about two words that we often use interchangeably kind of in day-to-day conversation, privacy and confidentiality. So to clarify the difference, privacy is a person's constitutional right under the U.S. Constitution to decide how much personal information can be shared with other people. Whereas confidentiality exists within the professional relationship. It's the obligation for those of us who have a professional relationship with another person not to disclose any information about a client, research subject, supervisee, or employee that was obtained during the course of our professional relationship without that person's permission. So privacy is an individual right under the Constitution. Confidentiality is an obligation that arises within the context of a professional relationship. So HIPAA, the Health Insurance Portability and Accountability Act of 1996, its original form. HIPAA is two A's, not two P's. It's not a hippo, it's a HIPAA, okay? All right, make sure it's spelled right on your resume. So under HIPAA, this is a law that protects privacy of patient health information. This applies to health and mental health care providers who may transmit health information in electronic form. This transmission can include things like electronic billing or use of a billing service that transmits information electronically. So if we bill Medi-Cal, for example, that would be a covered entity, and that would be considered a covered transaction. Covered meaning covered under HIPAA laws. So we want to make sure that under those situations we understand we are covered under HIPAA. PHI refers to individually identifiable information in any form, whether oral or written or electronically transmitted. So when we think about protected health information, or PHI, it's health information identifiable to a specific individual, again, that's maintained or transmitted, so maintained in files, for example, or in one's computer, or transmitted by a covered entity in any form, whether that's oral, through paper, or electronic means. So this could include things like an actual old school paper chart, a bill for service. It could also include a conversation that happens in the hallway. So we need to be aware that PHI can be expressed or shared in any one of these kinds of settings. And we also need to make sure that while people often think of PHI as being a patient's name and or date of birth, we need to be mindful that it also includes other demographic information, but it's not limited to that. So it could include address, age, racial or ethnic identity, gender identity, those kinds of things. It's important to understand the PHI has a wide range what it captures in terms of identifying a person. So I want to understand a couple things with you relating to standards and rules under HIPAA. There's first what we know as the privacy rule, which a lot of you may have heard in your practice, which involves communicating only the minimum necessary disclosure to accomplish the intended purpose, right? And this is something that we'd attend to under the privacy rule, even if we have a release of information, right? We just because we can talk with another person and we have permission through a signed release, for example, to talk to a client we might be working with, their medical provider, doesn't mean that we need to get into all of the details about their most recent session or recent disclosure about some type of a transgression they may have kind of shared with us in therapy, for example. Just because we can talk to the doctor doesn't mean that we need to share all of that information with the doctor. We might just want to confirm that the person has seen their primary care physician, and that's something we need to check, and we're going to move on. So we need to be mindful about that, the privacy rule. Then there's the security rule, which defines confidentiality. Again, that gets at our professional relationship to mean that ePHI, meaning electronic PHI, is not available or disclosed to unauthorized persons. Okay, so when we think of security under HIPAA, it's not not just what we share with other people, but also that it's not available or unwittingly disclosed to people who shouldn't have access to it. So that means we have administrative safeguards, right? So wanting to think about administrative personnel, who has a need-to-know basis for patient information and role-appropriate access to client files, for example. Maybe not all administrative personnel need access to patient files. Being mindful about that. Physical safeguards, just as the name suggests, we'd want to think of the physical space, having things be locked, for example, and then technical safeguards, right? So things like that happen in the electronic sphere, in cyberspace. We also want to think about other types of technical safeguards when we think about how we might share information through standard encryption and things like that. So it's important to understand that whether or not we are viewed as a covered entity under HIPAA, so while we might not be billing for services, or we might not be in the role of a psychotherapist, for example, which is typically considered a medical role, whether we're providing that in a medical facility or not, HIPAA has really come to be understood, has come to be understood, as the standard of care in social work practice more generally, right? And so many of you already know that school social workers may or may not provide psychotherapy, for example. We may be coordinators of wellness centers, we may be facilitating other providers coming into the school and providing psychotherapy, for example. But even if we are not ourselves providing that service, it is important to know that the NASW and other professional organizations to which social workers often belong really view HIPAA as our standard of practice as a profession. So that means that we need to really be thinking about both client privacy and confidentiality in making sure that we take what are known as reasonable steps to protect the security of people that we work with, their PHI. So that includes things like record storage. So if you have old school paper charts or physical charts, they should be behind two locked doors, right? So a locked door to the office and then a locked filing cabinet would be an example. Digital security, wanting to make sure that there are robust passwords, firewalls, encryption. It used to be that, kind of mostly county agencies had solid encryption plans for their email, but in recent years, nonprofits have also, had staff download apps on their smartphones and also through their email programs to ensure that their email that may be sent to clients or other people outside of the agency is properly encrypted. So again, even if we have a release of information, we still need to take these precautions. This is viewed as reasonable steps. Okay. Fax machines, kind of old school. I might date myself by bringing them up, but if you do collaborate with hospitals or working within a medical center, this is definitely still viewed as one of the more, or if not the most secure, which it can be ironic in some ways, which we'll talk about, but fax machines are definitely still used in schools. It's important if you are sending a fax that you take these reasonable steps to call ahead, verify the fax number is correct, and ensure that the appropriate recipient is waiting for the fax. Best practice is also to call back and make sure they received it. I've worked in schools in a variety of roles, and currently as a clinical supervisor at a school I won't name, but I once was, there to visit with and meet with a staff person for supervision, and I was waiting in the common area and the fax machine in the common area for staff, and the fax machine went off and it spit out about 30 different pages of paper. It was a hospital discharge plan. They were falling all over the floor, and there was no one there to receive them. It's not uncommon for, as I said, hospitals to send information this way. And again, if we're faxing CPS reports or other things, it's important that we make sure that we're attending to them on our end. Voicemail. Please make sure that we have permission to send voicemail, and also text messages would also fall here. Just because a client has given us their phone number doesn't mean that we have permission to leave a message. They might share that voicemail or that phone number with someone else. We want to make sure that we have a clear understanding of what's okay to leave on a voicemail. And similarly, if we have permission to text, many agencies now have email, voicemail, and or text permission kind of checkboxes where we ask clients to explicitly give us permission to communicate with them in these ways. So it's important for us to think about all of those as what are considered reasonable steps. And again, this is true whether or not we're acting in the role of a psychotherapist, whether or not technically we fall under HIPAA. As social workers, this is really viewed as our reasonable umbrella. Also want to get into talking about FERPA, right? So FERPA is the Family Educational Rights and Privacy Act that really governs the realm of schools. It covers institutions and students who receive federal education funding. This includes both K-12. It also can include early education and college and graduate level, right? Like our graduate studies are covered under FERPA as well. It protects the privacy of educational records, and it controls the disclosure of written information maintained in educational record. So if you are a social worker in a school, it's important that you understand FERPA. It's important to know that information directly related to a student here refers to any information that alone or in combination is linked or linkable to a specific student that would allow a reasonable person in the school community to identify the student with reasonable certainty. Okay, so just like PHI means, doesn't just mean that we use a person's full name or their first and last name connected with the date of birth. PHI recognizes that, hey, sometimes people can be readily recognizable with less information than that. So too in FERPA, so we need to be mindful that just using initials alone, for example, is not sufficient to protect a student's privacy. It's important, really important to understand that parents, and here I mean people who have educational rights, so if we're talking about youth who may be in the foster care system, it may be that someone else is holding educational rights, but whoever is that ed rights holder has the right to access all records that are subject to FERPA, okay, regarding their minor child. So if a parent or ed right holder is, related to or responsible for someone who then turns 18, at the age of 18, then they are no longer considered a minor and would be able to access their own records. But in thinking about a minor, parents or ed right holders have that access. So it's important to understand sometimes schools will give us, as school social workers, we may have access to certain databases. I've worked and consulted with some school districts who have said, hey, there's this kind of section of the database that no one knows about, this is just for the social workers or just for the therapists to jot down notes. If you could just acknowledge when you're meeting with students and maybe whether you had to make a CPS report or something like that, and no one else in the school even knows it's here. Well, technically, if it's part of the school database, it's part of FERPA, it's part of the educational record, and it's important to know that parents can access that information, right? And so, hopefully if we're working with youth, we're also working with their parents or caregivers, but it's also important to understand that we don't need to share all of that same information with their parents, and so we want to be really thoughtful about what parents do and don't have access to in terms of student records. It's also important to understand that information can be shared with any school staff who has a legitimate educational interest in the information itself, but that information may not be shared with outside agencies, staff, or those without a legitimate interest. Okay, so sometimes people who may be viewed as having a legitimate interest, and really that is defined by the district itself, so that's important to know. But for example, those with a legitimate interest might be mobile crisis first response, for example. Schools may decide that in a crisis situation they would share that with a relevant mental health mobile crisis team, if there is such a team in that district's location, to share if a student's in psychiatric crisis or is believed to be. That might be an exception, right, where they can make that determination under FERPA. However, so long as the person has legitimate educational interest, that information can be shared. So if teachers may talk with other teachers who are working with the student about how that student is doing, they are not protected under HIPAA. They can talk about that student, with other people with a legitimate educational interest. So you may find as a social worker in a school that the level of communication might be more loose than what you are accustomed to, being trained and kind of holding the professional standard that we do in social work as under HIPAA, which can be a lot more stringent in these areas. Here, you may find people sharing information or asking you to share information in ways that feel like they were contrary to your training. So it is important to understand kind of how these policies impact schools and how that may impact how teachers view what's acceptable to talk about. So when we think about what is the educational record, it's defined as written records, also old school written files, documents, or other materials that contain information that are directly related to a student, and they are maintained by an educational agency or institution or a person acting for such an agency or institution. Okay, so it could be in the school's database, or it could be a person who is working for the school that maintains such a file that has information that is directly related to a student, okay, in the course of their professional capacity. So it can be a kind of a wide definition of the educational record. It's not just the CUME file, for example. Other written records or files or documents could be things like cost meeting notes, for example. So it's important for us to know that. Similarly, we should know what educational records do not include, and it does not include records that are kept in the sole possession of the maker, are used only as a personal memory aid, and are not accessible or revealed to any other person except a temporary substitute for the maker of the record. So you might be like, wait, what does that say? Right. So the law can sometimes be written in these sort of legalese. But it's important for us to understand here what is not part of the educational record so that we can be mindful of that in our own documentation and note-taking and note-keeping. And this is what I fondly refer to as the Hello Kitty notebook. So I'm not really sure why I picked Hello Kitty per se. She just came into my mind one day as I was sharing this idea with social workers, and it has forever after in my brain become the Hello Kitty notebook, which is not an official thing. I am saying it somewhat tongue-in-cheek, but my point is that if you have a Hello Kitty notebook or a notebook that you put Hello Kitty stickers all over, or something that is clearly not the blah blah Unified School District file or the blah blah Unified School District laptop, it is clearly something that is just yours for your own notes. You might jot down a couple quick memory aids to help you remember something important that a client brought up in a session, but is not something that you make available. It's not your official notebook of your work in the school. And it's not something that other people can use unless, let's say, you're out for a day and you need to give it to a temporary substitute, but I wouldn't even recommend that. This is something that is just yours alone, that is not considered part of the educational record. And so the way that some social workers address this issue and kind of addressing FERPA and the potential for things to be made available to parents if they have access to the student's record is to keep keep the documentation for the school at a very bare minimum. What is essential, which also goes back to our good practice and thinking about sharing minimum necessary, right, as we think about the privacy standard. But that can be one way that social workers address this issue, is to keep their Hello Kitty notebook. We'll talk about what to do with the Hello Kitty notebook and maintaining it under HIPAA guidelines, because again, that's the standard of our profession. okay? But something like that would not be considered part of the educational record. The educational record also does not include things like records of the law enforcement unit of an educational agency. So, for example, if there's a school resource officer, they may keep records that are maintained in the normal course of business that relate to their capacity as a law enforcement employee and are not made available for use for any other purpose. Okay, so that would not be part of the educational record either. So, if you're a school social worker, do you follow FERPA or HIPAA? So it still a little bit depends on the situation. So HIPAA rules do not apply to health information that's held in an educational record that is subject to FERPA. In other words, FERPA kind of supersedes HIPAA in terms of making sure that the information is available to the educational rights holder for a minor child. I do want to point you to this resource that is hyperlinked on bCourses through our colleagues at the California Adolescent Health Collaborative. Did a great piece called "What Do I Follow? HIPAA, FERPA, or California Law?" I just created new acronyms. And on their larger publication, "Understanding Confidentiality and Minor Consent in California," is a really great resource that really unpacks this a bit further. So I encourage you to check that out if you're interested. So as we think about more on this question of FERPA or HIPAA, student health records maintained by employees like school district employees who are nurses, school psychologists, or school social workers of schools that receive federal funds are typically part of the educational record that's subject to FERPA. So if there's a district nurse, a school psychologist, their notes, their assessments, etc., that kind of information is subject to FERPA. Okay, and then also that includes us again as school social workers. So if you are a district employee and the school you work for receives federal funds, which all public schools do, that's important for us to know, that even if they're considered health records. So, however, school-based health centers, and there are a few of them in my experience in the Bay Area, there are very few that do this, but there are some that transmit PHI electronically for billing purposes. So, for example, if you have a clinic within a school, like the school health center, let's say at Berkeley High School, that is a school-based health center that transmits PHI electronically for billing purposes. They bill Medi-Cal, and the folks who are there are employees of Berkeley Mental Health and Berkeley Public Health, I believe. They are not district employees, but they have the health center inside the public high school. In that situation, their work falls under HIPAA. Okay, and so part of what that means is that there is a privacy wall, right, and a confidentiality wall between the school and the health center, meaning someone who works in the health center, the nurse who works through public health of the city of Berkeley, would not walk down the hallway at the school and just tell a teacher the results of a student's medical test, right? They're covered under HIPAA, and they would therefore need a release, an appropriately administered release of information to share that kind of information, and only then the minimum necessary to share with an appropriate person. Okay, so it can be confusing. So just because you work in a school, or your desk is in a school, or your email is a school district email, that's not always the clarifying factor here. So hopefully this helps a little bit. Also want to consider the designation of the U.S. Department of Education. Is that student-based health center a non-educational agency? In the example that I provided, the Berkeley Health Center is a non-educational agency, meaning it is an agency of the city of Berkeley, Children and Family Services or Youth and Family Services Mental Health Division and their Public Health Division, which is separate from the high school staff, for example. Okay. So, in a school setting, student health information that's in educational records is typically protected under FERPA, but health information contained in personal notes, like the Hello Kitty notebook, that are not in the educational record are not covered under FERPA, but they may be subject to HIPAA, right? So remember, even, you know, as a HIPAA covered person, let's say you are a therapist where it's really clear, bright line, you're covered under HIPAA, you work for a mental health agency, and you have a book where you keep all of your notes about voicemails you receive from clients. That includes phone numbers and the names of the person calling. Even if it doesn't have your client's name all over it, it has identifying information in it, some, you know, that a person may be able to put back together, right? In that case, you wouldn't bring that notebook and just throw it on the kind of dashboard of your car and run into the grocery store and leave it there in plain sight. You would make sure that it was behind two locked cabinets, right? Remember that as social workers, HIPAA is considered, again, whether we are considered medical professionals in our capacity or not, HIPAA is considered the professional standard under which we are typically viewed as being accountable. So we want to be mindful, even with our Hello Kitty notebook, to not just leave it out, not share it for other people, that we need to protect it under the guidelines of HIPAA. Aside from this, there are also California confidentiality laws, right? HIPAA and FERPA are both federal laws. We have state laws here in the state of California that coexist with both FERPA and HIPAA, and with their own directives about disclosure and or protection that sometimes conflict with federal law. There are multiple places where state and federal law may sometimes conflict, and so in those cases it's important to seek legal counsel when there is that conflict, or if you're unsure about disclosure. Before seeking legal counsel, of course, I hope that you are also first consulting with a supervisor, right, appropriate supervisor. Depending upon your service context, you might have access to county counsel or an attorney that represents the school district if need be. But in general, definitely start with a supervisor and make sure that you are not disclosing information that is outside of your scope. So just a couple other reminders about privacy, confidentiality, and also discretion, which is, you know, not really a legal term, but is more of kind of a respect, right? Kind of common respect. Schools are big and open spaces, as you know, and space is often as a premium for us. You know, I don't know about you, but I've worked in closets and trailers and, you know, corners, and not, you know, always having a room with a door, right, where we have the privacy and the sound machine and the whole 9 yards. So how do you think about, you know, maintaining privacy, confidentiality, and discretion within a school setting? A couple things to think about: front office policies and procedures. Just be mindful of the visitor sign-in protocol, right? Together with the pens that have the little flowers on the top, and, you know, the stickers that say visitor with an apple on it, right? Next to all of those are often binders at the front of schools, right? And there might be one where parents sign kids in and out, where volunteers might come. Many schools also have one that's set aside for CPS workers, and I was at a school once where I was signing in to go meet with one of my supervisees, and I saw that someone picked up a CPS binder and was looking through it, and it turned out that that was a parent, right? And if you look at that binder, you would see the way that the school had that particular binder set up. It said CPS worker, county affiliation, and something like name of student here to see. And so you basically are showing in a binder, right, at the school, who's there to see what kids to investigate or to meet and follow up about allegations of child abuse or neglect, right? Now, you don't have control over that necessarily as the school social worker or a social worker in a school, but I just want to point that out as one of many ways that we're not always attending to people's privacy and discretion and being discreet and maintaining confidentiality. Particularly when those binders are unattended at the front office. Now, if that same binder was available and only on a basis where the staff had to give it out if the CPS worker showed their badge, that would be a little bit better. But attaching the name of a worker with the name of a child also lets future workers, if they look at who was before them on the sign in and sign out log, that's definitely not the most discreet option that one could choose. Student health center policies, I know some schools have, the wellness center, all their passes are green or they're purple or whatever they are. That can sometimes flag kids to other kids in a classroom. If you send a pass down for a kid to come see you, the pass comes in, everyone in the room sees, oh, it's a green pass, that means you're going to go to the wellness center, that means you're in therapy, or maybe you're going for a sensitive service for like, birth control or, other related sensitive services, right? We don't want to kind of set kids up to have their privacy compromised, right? So being mindful about even subtle things like that that are, can readily be identifiable in a school. If where you're seeing kids has a registration area, that's kind of a luxury in a lot of spaces, but being mindful about, the privacy line and, making sure that people step back from the registration desk and that there's privacy in between people who are checking in. That there are privacy walls, and sometimes wellness centers or places like this may have kids sitting right by a window, so anyone who walks by knows who's in there, possibly getting services. Are there ways to add layers of discretion to that environment? That's something for us to think about. Of course, we want to think about our conversations, right? We want to have those in private and not in hallways or classrooms or parking lots. Again, you may find that teachers or other school administrators that you work with are used to really different layers of kind of discretion than you might be as someone who has also been trained under HIPAA. And so just to be thinking about, even if HIPAA doesn't apply to you in those spaces, really be mindful about where you're having conversations, and remember that we also are covered under, if we're covered under FERPA, we need to be mindful of that as well. So we shouldn't be talking about students in front of other students. You might walk into a classroom towards the end of the day and a student's still packing up their backpack and a teacher's like, oh, hey, are you still seeing Kim in therapy? And kind of says it over the head of a kid who's in the room, who's not Kim, who's not the one the teacher's talking to you about. We need to be thoughtful about those kinds of things and say, hey, let me check in with you. I can't say either way, but let me check in with you about that kind of stuff later. Sometimes teachers need to be reminded of that, or they're really busy and you're really busy and they might try to catch you in the hallway. So finding ways to be both respectful and appreciate the teacher's interest or appreciate their care or concern, but make sure that we can find ways to protect student privacy while having those conversations when they're appropriate to have. Okay, so you made it through. So a couple things here at the end. I want to ask you, when you think about FERPA and protection, how is the image in A related to the image in B and C? How is the image in B related to A and C? And how is the image in C related to A and B? All right, so send me your response for some extra credit, and I will look forward to checking that out. Thanks so much for your time and attention, and I look forward to connecting with you. If you have any questions or concerns, please send me an email or we'll connect at our next gathering. And I will see you next time. I've never done that before. I'm super proud of it. Okay, thanks. Bye.